Spousal support, which is sometimes called alimony, is money paid from one spouse to the other after the dissolution of a relationship. The obligation to pay spousal support is a legal one and may arise either from a marriage or from a common law relationship. The obligation for one spouse to pay spousal support to the other spouse does not automatically arise from the fact that the parties had a relationship together, whether formally married or common law. Rather, the spouse who is claiming spousal support must prove an entitlement to it. A court may order spousal support and will set an amount and duration based on various factors that exist between the parties. The jurisdiction for the court to award spousal support comes from either the Federal Divorce Act or from the Ontario Family Law Act. The determination of how much support a spouse should receive and for how long is a complex equation. In making a spousal support order, courts consider several factors, including the length of the entire relationship, including time living together before marriage, the financial circumstances of each spouse, both during the relationship and after separation, the functions performed by each spouse during the relationship, the financial repercussions or detrimental financial effect on one or both spouses of caring for each other or any of the children of the relationship, and each spouse's ability to support him or herself. In some cases, one spouse may have suffered a financial loss or disadvantage as a result of the joint career and lifestyle decisions made during the marriage or relationship. For example, the decision to move the family so that a spouse can take a new job, or that the mother will give up her career and stay at home and raise the children. The disadvantaged spouse will be entitled to support to compensate him or her for that setback. There may also be a limit on the duration of the support that one spouse receives from the other, as a means of encouraging the recipient spouse to achieve post-separation financial independence as quickly as possible. Alternatively, the order may contain a built-in review mechanism. Generally speaking, the entitlement to spousal support is not dependent on the spouse's pre- or post-separation behavior or ethical conduct. In other words, a spouse who is otherwise entitled to spousal support after the dissolution of a marriage will not become disentitled because he or she was violent or because it was later discovered that he or she had an extramarital affair during the marriage. Having said that, a court's determination of the amount and duration of spousal support will hinge upon each party providing forthright, comprehensive financial disclosure to each other. If in making the determination the court feels that one spouse has withheld financial information, such as failing to disclose a significant income, the court may impute income to that spouse and award the other spouse his or her support accordingly. As indicated above, the notion of one spouse receiving spousal support from the other is rooted in several concepts and principles, including the financial disadvantage or dependence that the relationship gave rise to must be readdressed post-separation, and the ability of the spouse to fund spousal support award must be taken into account. The amount or duration of spousal support may have to be adjusted if there's a significant change in the financial circumstances of either party. This change must be significant and must not have been foreseen when the separation agreement or court-ordered spousal support was made. We hope you've found this video helpful. If you require further information about spousal support, please give us a call or visit our website.